UCC. What is the UCC? Uniform Commercial Code. And I know from a show of hands that everyone's had Business Law 1. What kind of law is the Uniform Commercial Code? Is it, I mean, what category of law does that fall under? Is it state law? Is it federal law? Is it, I'm sorry? It is commercial law, true. It's dealing with commercial transactions. But is it state enacted or is it enacted at the federal level, do you think? Very good. So short answer, state law, but the more longer answer is, well, feeding off of the word uniform, that it is a body of commercial law that a number of states have adopted in a uniform fashion such that the law in New Jersey does not vary so much as from the law in California or the law in Connecticut or the law in Arkansas. Because, I mean, you know, again, the objective here being that this is a way to sort of simplify commercial transactions. Okay? So yes, it is state-based law. And if it's state enacted, it is state statute, right? And I'm trying to differentiate that, for example, from court cases, right? And the word we sort of give to court cases in the law is we call it common law, right? So this is not, you know, when we talk about contract law, when we're talking about certain types of commercial transactions, we actually have a statute. We actually have state law that guides a lot of these things, and we don't have to look at common law as precedent to guide us, right? And I'm not saying that this exists in all contract law, but it exists, for example, in sales and lease contracts, right? And that's where we're going to try to pick up as we start this course. We're going to pick up with the portion of the Uniform Commercial Code that deals with sales and lease contracts, okay? All right, so again, what is the UCC? Well, it's a model act or a uniform act that basically tries to give us a set of comprehensive rules that cover most aspects of commercial transactions. So yes, we'll start off with sales and lease contracts, but then we'll talk about negotiable instruments, we'll talk about bankruptcies, we'll talk about the banking system and so on, and we'll see that those are all different articles within the UCC in looking at different types of commercial transactions. So we're starting off with Article 2, right? So if you know, I don't think this version of the textbook does it, but an earlier version of the textbook actually gave what Article 2 looks like, right? It is just a bunch of rules. Section, you know, Article 2, Section 2-101 says this. It has definitions. You know, this part deals with one concept. This part deals with statute of frauds, and so on and so forth. So, you know, there's no mystery to what the Uniform Commercial Code is. It's basically a compilation of rules that has, you know, if you look at a book, you've got different chapters, right? So if you look at the Uniform Commercial Code, you've got different articles with sections underneath. So if I open up the Uniform Commercial Code, I'll see Article 2 that deals with sale of goods. I'll see Article 2A that deals with leasing of goods. I open up Article 3, it'll have the rules relating to negotiable instruments. Article 4 will deal with the banking system. So, you know, that's how this is set up, essentially. So at first, we need to first understand, if we're going to use legal terminology, well, what does that terminology mean? Right? So Article 2, where we start off with the Uniform Commercial Code, governs the sale of goods, right? And you'll see that when we talk in business law, we want to understand what each of these terms mean. Yes, we use the word sale all the time in the English language, and we use the word goods in the English language. Well, what does that mean in this context when we're talking about the Uniform Commercial Code? Well, sale means the passing of title from a seller to a buyer for a price, right? Title. I mean, is that a word we throw around quite a bit? When you buy something, when you buy goods, do you say, I have just bought title to a brand new handbag? Yeah. No, I don't talk that way, right? So, I mean, you know, when I think title, I think title to a car, right? I don't necessarily think title to a laptop that I just bought. So obviously, this terminology is sort of archaic in some ways. What they're really talking about is the passing of ownership from a seller to a buyer for a price. Okay, it's a sale as opposed to a gift where there is no price, where there is no consideration, if we're going to talk contract law terminology. Okay, so that's what a sale is. What are goods? Right? I don't say I'm going to the mall to go buy goods, right? We just don't speak that way. But on the other hand, the items that I'm purchasing do classify as goods, right? So what are goods? Well, goods are tangible things. What does the word tangible mean? You can touch and feel. And I challenge you that when you read the textbook, when you read the slides, when you hear a word that you just don't understand, either look it up or ask, right? Don't keep reading because you just won't understand the rest of the stuff that comes after it. So you're right. Tangible things are things you can touch and feel that are movable at the time of their identification to a contract, that are transportable, okay? Yes, a handbag, a laptop, and all of these things. A house, technically not so movable, right? So we'll see that certain things are not subject to Article 2 because they don't constitute goods. And Article 2 only applies to the sale of goods. So for example, money and intangible items are not considered tangible. Money is sort of esoteric, right? Intellectual property, right? Valuable property, a patent, I'm not diminishing its value, is just not tangible goods that is subject to the UCC. It is subject to federal law, as we know, right? It is just not subject to Uniform Commercial Code. Real estate is not tangible, movable, and it's not as if we're in the wild, wild west and no set of rules apply to sales of real estate contracts. Of course they do, right? It's just not Article 2 of the UCC. Article 2 of the UCC only applies to the sale of goods. One more thing that is on the slide that is not covered under UCC Article 2 are services, the sale of services, right? Hiring someone to mow your lawn, hiring someone to come in and fix office equipment and so on is a sale, but it's a sale of services that is not subject to UCC Article 2. Well, if UCC Article 2 doesn't apply, what do you think does apply? What if there's a dispute under a sales contract? What do you do then? Do you have no recourse under the law? What's that? You do, but where is the source of law, do you think? And I've sort of hinted at it. If you don't have a state statute, what else could you look to? Yes, common law. You could look at precedent, right? So, and if it's real property, there's real property law. So it's not as if you're left without recourse. It's just that we're not talking about the Uniform Commercial Code. Okay. All right. We've said that services, contracts for the provision of services are not covered by Article 2. Well, the way I look at the world, it's not usually all that neat. It's messy, right? That's true in general. Well, what if you have a contract that is part goods, part sale of goods, part sale of services? Now what? Right? There's always going to be a monkey wrench here. It's not neat. We can't say it's just sale of goods, Article 2 applies. It's just sale of services, common law applies. What if you have a sale that involves goods and services in the same transaction? What if a business is buying office equipment? They're buying a copier, a fax machine. I don't know who uses a fax machine anymore, but they are. They're buying a scanner, and they're buying all sorts of things. It's a big office. They're buying a ton of equipment. And when you buy equipment, you know that it's going to break down, right? So you buy a service contract with the equipment from the same company that says for the next 3 years, if something breaks down, someone will be in your office within 24 hours and fix it within the price of this contract. So you're paying thousands of dollars for the purchase of equipment and some component of it for servicing that equipment if it fails, which inevitably it will. So what do we have there? We have a mixed sale, right? We have a seller that has sold for a price goods and services, right? Does Article 2 apply or not apply if, for example, there is a dispute over that contract? Answer, it's on the slide. Article 2 applies to mixed sales only if the goods are a predominant part of the transaction. Well, what does that mean in English? Say that again? If the goods are a higher percentage. I will challenge that a little bit, but you're on the right track. You know, if it's a large enough part of the transaction, is there a bright line rule there? Can I say, you know, you're almost saying 50-50, right? Is it, you know, do the goods have to be more than 50%? Does it have to be 60? Does it have to be 70? Well, the general rule here is that there's no, I mean, the UCC is going to give us governing principles. It's not going to have those kind of bright line rules, right? It's going to give us predominant part as a way of looking at the facts and circumstances of a particular case and deciding whether or not in that context one could argue that goods were somehow the predominant part or the services were a large enough component that maybe Article 2 should apply. Now do you see how we almost, this is crying out for a case. It's crying out for a scenario. It's crying out for applying the facts, and guess what? We have one. So you'll see that a lot of these chapters have a fair number of cases that we wind up talking about. And I think this case was an interesting case. This was a case involving you know, a quote-unquote sale of items that were both goods and services. And this was, and I always sort of look at a court that decided the case, the Supreme Court of Illinois. Does that sound like a federal court or a state court? Well, a state is explicitly mentioned, so let's just say this one is easy. Yeah, it's the Supreme Court of Illinois, so it's the highest state court. It's sort of, I marvel at the fact that this case made its way from a trial court to an appeal court to a state Supreme Court when the issue seems rather simple, right? But, okay, this is when I say to someone, tell me about this case. What happened here? And I'm not looking to find out you know, the names of the parties so much. I'm just looking at what was the issue? What happened? Yes?
It was a woman.
Yes.
Had surgery, and the implant that she had made like a really bad.
It malfunctioned.
Yeah, malfunctioned. So
Right.
they had to take it out.
So woman had surgery where? No, not a part of the body. Was it at home? It was in a hospital. There you go. Yeah.
The hospital provided the service.
Right.
But the company that provided the product was Boston Scientific.
Correct.
Corporation.
Right. And it was known that this product was faulty, and unfortunately she suffered some adverse health consequences, and she winds up suing. You know, we are a litigious society, and when things go wrong, we wind up suing each other. And here, this woman wound up suing two different parties. She sued Boston Scientific, which we know provided a faulty product, but she also winds up suing the health center, the hospital, based on, you know, this wasn't a case of malpractice, right? You're not suing the doctor for professional negligence, as we read the synopsis of this case. This was that you know, that you sold me a faulty good. Okay, that might work against the company that manufactured this device, but the question is, does this work against the hospital that, yes, performed the surgery and did use this device and put it into her body, but, you know, what kind of, you know, I mean, are they subject to an Article 2 kind of a lawsuit? So the question is the transaction between the plaintiff and the hospital predominantly the provision of services, in which case Article 2 does not apply, or for the sale of goods, in which case it does apply? And what did the court say? Yes.
For the service, because most of what a hospital provides is a service, not a good.
True. And did they look at any numbers in this case? Right. Do you kind of remember what those numbers were, just to give us a gauge? Because someone here said, well, it could be majority, right? Yes. And you don't have to give me exact numbers.
The number that they say for the item they
no, I think it was itemized on the bill, if I recall correctly. Well, let me just my recollection is, let's say the surgery was around $12,000, something like that, right? And the device cost the hospital like $1,500. So if you do the math, 15% of this sale, if you want to call it that, comprised of the goods, and 85% of it comprised of a physician's services to actually perform the surgery. And here the court said, yes, it is clear that the predominant part of this transaction was a sale of services, in which case Article 2 does not apply, right? That doesn't mean that this case cannot progress against the manufacturer of this device, but if you're going to sue the hospital under the theory of you sold me something faulty, that's not going to work, right? Now, if the physician was negligent and committed an act of malpractice, that's a different story, but that is not something that we gather from the facts that they provided here. Do you have a question? Well, but again, we can only surmise by what's here. This came out after the fact. It's not as if they were using a faulty device that was in the news as don't use anything made by Boston Scientific. What we find out often is things are recalled, things are made negligently, and this came about after the fact is what we can kind of surmise here. Okay, moving on. Yes, I'm sorry. No, actually the opposite. Oh, let's say if it was. Okay. Yes. Yeah. So the question is, what if things were flipped? What if, let's get out of this hospital business, and let's just say that, on the off chance that we can skew the facts that what I'm buying, actually the price of the goods is only 15%, but the service contract, the fact that someone has to come in to do certain things to it is the vast majority, or did I say that the opposite? Yeah, I said the opposite. Okay. The answer to you is yes. Yes. If the goods were the predominant part, then, actually my office contract is exactly that, isn't it? Isn't it? The example that I gave, that you buy all this office equipment, but the service component is some part of it, most likely would be UCC Article 2, because that's just assurance. I mean, if you're paying $100,000 for office equipment, if you had to independently price out what the service contract is, maybe it's $3,000 or $4,000, it's clearly going to be subject to Article 2. And even if you have a dispute over the service, it is still going to be governed by UCC Article 2. What if it's in between? Everyone wants to know the answer to the harder question. What if it's 50-50? Is that what you're saying? It's facts and circumstances. It really, really is. Now, with the law, you almost can't ever answer a question numerically. What if you do the math and it's clear that it's 50% goods and I would argue that a reasonable court, and believe me, the reason cases gets appealed is because reasonable minds do differ. It's possible that a court could say predominant could be less than 50%, but most courts would argue that it would have to be substantially more than that just for something to constitute predominant. But again, that's subject to interpretation. It's subject to facts. Okay. What else? All right, we know what sale is. We know what goods are. We know what a service is. We know what Article 2 does not apply to. Now, does it matter who's involved in the transaction, right? There's always, when we're talking about, for example, a sale, we're talking about a seller and a buyer, and they don't have to be individuals. They could be commercial parties. They could be corporations and so on. Does it matter if a seller or a buyer is a professional seller or buyer? And by that I mean if they are, quote unquote, a merchant, right? And again, I don't, in common everyday talk, we don't use the word merchant all that much these days, right? But this is UCC terminology, right? This is still a little bit archaic. So how does the law define a merchant? Well, a merchant is one who deals in the goods of the kind involved in the transaction, or by his or her occupation, holds himself or herself out as having knowledge or skill. Okay, it's a professional buyer or a professional seller. I mean, if I open up a storefront and I'm selling things, I'm a merchant. If I decide to sell you my used car, I'm a non-merchant, right? I do other things for a living, but I'm engaging in a sales contract, but I do not deal with selling cars for a living, right? So why am I talking about this? The reason I'm talking about this, and this is important, and it's not necessarily on the slides, but it's in the books, but it's a concept that you need to understand, and a lot of people sort of get this wrong. The UCC applies regardless of whether the seller or the buyer is a merchant or not a merchant. It will apply. The difference is that there are certain rules that might be different for merchants versus non-merchants. And we'll highlight a few of those rules as we go along. And what we'll see is that the UCC is tougher on merchants than they are on non-merchants. The idea being that if you are someone that is in the business of, for example, selling something, you should be held to a higher standard than someone who engages in a one-off kind of a transaction and is just an ordinary layperson. Does that make sense? Okay. So yes, we'll talk merchants, non-merchants, but the UCC does apply to both. Leases. Remember we said that we're going to cover different articles of the UCC, and Article 2 of the UCC relates to sale of goods. Article 2, capital A, relates to the lease of goods. And in the next few chapters, we will talk about both sales and leases, but leases are sort of the stepchild, right? I mean, kind of it's the same sort of rules, but we're focusing far more on sale of goods than we are on leases of goods, although we're acknowledging that it is common for example, for businesses to not outright buy something, but to lease goods as well, right? And those leases of goods leads to a transaction where the lessor and the lessee have responsibility. So what is a lease? Well, a lease is a transfer not of title, right, but a transfer of right to possession and use of named goods for a set term in return for consideration. Don't you love legal terminology? Don't you always have to break it down to what the heck does that mean? Well, what it means is that someone has the lawful right to have something, to possess something for a period of time, right, for a set term, in return for certain consideration. Everyone remember the word consideration from Business Law 1? What does consideration mean? Get that coffee going. What does consideration mean? Well, it's one of the components to what is a valid contract, right? It's what distinguishes contracts from gifts. What it means is that one party has given something of value to another party. So really, it just means that one party is paying somebody for the privilege of leasing something, right? It's a tit for tat, right? It's not a gift. So yeah, I mean, we know what a lease is. But, as I've said, as I always sort of say, we can't, in the law, talk about parties without naming them. We have to give cute little names to all parties in a transaction. So if we're talking about a lease, we're going to have a lessor and a lessee, right? Who's a lessor? A lessor is a party who transfers right of possession and use of goods, somebody that will allow somebody else to lease their property. And here we're talking about goods, right? It's Article 2 of the UCC. Who's a lessee? A person who acquires a right to possession and use of goods. So let me make this more real world for you. If I have a business and I want to get office equipment and I'm still, we know businesses run lean and mean, right? I cannot afford to buy the equipment, but I also cannot afford not to have the equipment to run my business. I choose that the more economical way for me to go about this is to lease the equipment, right? Now I have engaged in Article 2A of the UCC because I have leased the equipment. For example, I could do it directly from one of these companies where for the next 2 years I will lease equipment. and I will pay them a set amount, sort of rent, if you will, during that time, right? So it's the same sort of transaction. We're still talking about goods. Instead of outright title and ownership of those goods, I have the right to legally possess these items and use them during that time frame. I am the lessee as a business owner. The company who leases it to me is the lessor. Yes? No. So the question is, well, who holds title, right? And that's sort of a, are you thinking car leases by any chance? Probably, because as consumers, that's what we mostly think about. Kind of a slightly different transaction because, for example, so the question is, do you always have to hold title? And the answer is no. But the car lease example is a little bit different because a financing company often holds title, and that's sort of a financial arrangement, if you will. So leases differ in terms of what kind of a leasing arrangement are we talking about. Okay, now the example, and oftentimes we see these busy slides with arrows pointing all over the place and terminology, and it's like, whoa. The example that I just gave you on the last slide involved two parties to a lease, didn't it? The lessee, the business, was dealing directly with the lessor, right? The lessor owned the equipment. They were willing to lease it out for a couple of years and then take it back, right? But, yeah, that's a two-party arrangement. But out in the real world, leases are oftentimes a three-party arrangement, okay? And what we're really talking about here is a finance lease, for example. So here the example is of an airline, right? We've called them Jet Green here. Jet Green wants to have a fleet of planes to fly in order to run their business, right? Can't run an airline without some jets, right? Jet Green cannot afford to buy these jets outright, but they're willing to lease it. Boeing doesn't want to be in the financing business. Boeing will either sell to you or not sell to you, right? They're not going to lease it to you. So in comes financial intermediaries, right? They are willing to arrange for the sale. So here we've got a three-party transaction. We've still got a lessee, right? We've got the business owner that wants to lease something. However, in order for that lease to happen, we've got to introduce Citibank as a third party. Citibank is now going to become the lessor, right? I mean, banks do not sell airplanes, but banks will arrange for purchasing the airplane directly from the seller. They will hold title, if you will, because they purchased those airplanes. And then they will enter into a lease arrangement with the lessee. So here in this example, the bank becomes a lessor. The bank will set the terms of the lease. The bank will say this is a long-term lease with an option to buy. It's a 30-year lease, and this is what's required, and these are the charges, and so on and so forth, where the bank is a lessor, Jet Green is the lessee, and the seller is almost out of the picture after they deliver the planes to Jet Green. So this is a three-party arrangement where financing is involved, and this doesn't look all that different from a consumer car lease, for instance, right? I mean, it really doesn't look all that different. So understand that regardless of whether we're talking about two-party leasing or three-party leasing, leases are subject to Article 2A of the UCC, so long as we're talking about leasing goods. Everyone with me so far? All right, now I'm going to take you back a little bit to Business Law 1. But it's going to be Business Law 1 light, right? Because there is always, and I see like sighs of relief, which is a good thing. As I've always said when I've taught Business Law 1, the law of contracts is a big part of business law in general, right? And just because we learn about contract law once doesn't mean we forget about it, right? Contracts are sort of the basis. These private arrangements between parties are the basis for other topics and other subject matter as well. And we'll continue to sort of have these deja vus of these terms that we've learned about when we studied contracts more closely. Here, we're still talking about contracts, aren't we? We're just talking about a subset of contracts. We're talking about sales and lease contracts. But, you know, they have the same components. They have the same requirements that any contract needs to have. And really, just by way of a quick reminder, remember every contract has to have 4 components. And, you know, chime in if you want to. Remember, you've got to have 2 parties to a contract, right? You've got to have an agreement between those 2 parties. An offeror and an offeree have to reach agreement. You have to have consideration, don't you, right? We can't have one party not give something of legal value, right? Number 3, you've got to have legal capacity, right? You can't have parties that the law doesn't recognize as being capable parties of, you know, for example, it can't be a contract with a minor. Minor can make the contract voidable if they chose to. And then the contract has to be for a lawful purpose, right? The law will not uphold or entertain a contract that where the underlying legal purpose is missing. It's an illegal purpose, right? Those are the 4 components. Okay, so those are sort of the 4 overarching components of what it means to have a lawful contract. Now, remember when you go back to agreement between the parties? And there was this notion when we talk about contract law that, look, you have to be specific in terms of what it is that you're contracting over, right? Who are the parties, right? Because remember, a contract is private law. And, you know, I can enter into a contract with you, and as long as it's for a legal purpose, and as long as we are both of, you know, sound mind, that's fine. We have a dispute, we can go to arbitration. We can go to a court. We can get them involved in our dispute. But the thing is, we have to set out our contract in a way that a judicial trier of fact, an arbitrator judge, at least knows what the heck they're looking at, right? Who are the parties? What is it that you contracted over, right? You got to have certain basics before you could ask somebody to rule on your contract. Okay, we know that. So then we come up with this rule, something called the gap filling rule. I don't make up this terminology, I just teach it. And it's a rule that says that an open term in a contract can be read into a contract. Okay, do we just pull it out of thin air? No. What it means is that, look, the reason we have statutes like the Uniform Commercial Code is because we, as a society, as a legal system, want commercial transactions to flourish, to actually go forward, right? We don't want to act as a stumbling block. So we actually make it easier to, after the fact, have a sort of a set out way of dealing with issues, right? We want contracts to succeed, right? So we're saying that a contract is not going to fail simply because of a certain level of indefiniteness. For example, the parties are clear. It's party A contracting with corporation B, okay? We know there is consideration. And, you know, we know the subject matter of the contract, but the parties in their negotiations or the parties forgot to set forth certain terms. For example, you know, place of delivery. For example, what would happen if the price went up? How much, you know, how much would the parties have to pay one another? But we know that they intended to be involved, but there is this sort of missing component. What the UCC says is that you fill in that component. And how do you do it? Well, now you come back to my favorite word, which you hear over and over and over again in legal speak, and that is you use a reasonable method given the situation. So as long as there is a reasonable basis for reading in that term, the UCC requires the parties to basically do just that. So for example, you know, if you're in an industry where a supplier is supplying certain types of goods to a business and the price of those goods go skyrocket, right? And the other party wants to renegotiate, or they want a different price, or they really didn't build that into a contract. Well, you look to see what is reasonable under the industry norms. What are other parties doing, right? And you could have a contract go forward with price adjustment built into it that a court, that an arbitrator, that the parties would be forced to accept. The contract is not going to fail just because that term was missing from the contract. Why? Because we want contracts to be performed. We're not going to look for an excuse for a party to get out of a contract if it wouldn't be fair to the other side and if there's a reasonable way to deal with it given the circumstances of that situation. Okay? So that's sort of the idea behind the UCC, and that's what the gap filling rule is. If you've left out something and there's a reasonable way to interpret and give that term meaning, the law will require parties to agree to that. Everyone with me? Yes. Different issue. Hold that question. Not a mistake. Here we're talking about they didn't address it. But ask the question if you think it relates to gap filling. But I will get to a mistake because often, often. See, well, look, no. You should have thought of it. Well, listen, just because you're filling in a gap doesn't mean it's going to be on the most favorable terms to a party to the other side. Just the fact that it's overly detrimental to one side make it null? No. No, but remember what... No, look, I mean, no, it does happen all the time. The thing about it is, look, there are a number of different concepts that sort of come into it. You left it out by mistake. And remember what we said about mistakes in general under contract law. A unilateral mistake, unless, it rises to the level of being unconscionable, is, something that, look, you entered into a contract. You both had the ability to do whatever. You didn't. You left, it's too bad. It's not that it's too bad. It's just that you have to have a reasonable, objective way of looking at this, right? But if it would be completely unconscionable, if it were one thing, but if there's a reasonable way to remedy it, the law would say, fill it in. Okay. Yeah. They can go forward from there. And I think that's really the point here, Ronald, because it really is the issue of the law doesn't want you to go back to the drawing board. The law does want to take a component that is missing and build on that instead of, and have a contract be performed as opposed to saying, no, this contract is null and void. And that's something that the UCC does far more than common law. Okay, and examples of things that might be open are things like, and you might say, price? How could you leave the price open? Isn't that the most important thing that you want to put into a contract? Maybe, and in most circumstances, I would say the answer is yes, but it could be possible that the price of something is, is adjusted by external factors, and that's the reason you didn't put it in which case it's obviously something that can be filled in. So it is, you're not going to negate contracts based on technicalities. Payment terms. Is it going to be in cash? Is it going to be in installments? Is it going to be on credit? Those things could be decided upon later. Delivery, where, how, when. Again, that's not detrimental to a contract. Time. Well, I mean, as long as delivery is coming at a reasonable time, payment is coming at a reasonable time, you didn't make time is of the essence in a contract, contract's not going to fail. Assortment. And this is sort of this notion of, well, gee, if a seller doesn't have, you bought 100 dresses and, they have 99 in the color you want, but one not, okay, I mean, again, you're going to give a certain level of flexibility to sales and lease contracts. All right, we've talked about consideration already, right? It is a requirement under contract law. Sales contract is no different, lease contract is no different. Without consideration, without something of value, you don't have a contract to begin with, right? That's regular old contract law. under the UCC, and again, remember the objective of the UCC is to make things easier, to make things flexible, to make things work where they might fail under common law. Modifications to sale and lease contracts require no consideration. So a lot of you have learned in Business Law 1 that if under a contract you seek modification, you need some new consideration. This is a different rule for under the UCC. The UCC says, look, basically, remember the example I just gave a few minutes ago? The price of an item has skyrocketed, right? The whole industry, I mean, it's costing the seller 75% more based on market terms, market conditions, because of scarcity, because of whatever you want to make of it. Well, under those conditions, it would be a good faith kind of a standard applied where you could negotiate an upward. You will be required to negotiate an upward price that the buyer would have to pay, even though the buyer is not getting anything new, anything different, anything more from that seller. So it is possible that even without new consideration, you could have modification to a sales and lease contract as long as we're talking about those being done in good faith. And you got to love these words, good faith. What does that mean? What does that mean to any of you? I mean, when you read that word, as long as it's done in good faith, what do you think about? It's on the up and up. Yeah, it's for a proper business reason. It's not for fraudulent means. It's not, as you say, trying to get a better deal. It really is, you know, on par, up to snuff. I mean, pick any of these adjectives. That's really what we're talking about. Okay. I talked about agreement a little while ago, right? The first thing that you have to have in order for there to be a valid contract and an agreement only comes about if you have an offer and an acceptance, right? So, you know, and we saw, like when we talked in Business Law 1 about how acceptance can be one of those things that's sort of measured a little bit differently under our contract law. So for example, and this, you know, I'm going to ask people if they remember the name of this rule, a contract is created when the offeree sends the acceptance to the offeror, not when the offeror receives it. Unless, thank you, Ronald, unless it's otherwise stipulated, because you can always change those rules. What is that rule called under? Exactly right. And, you know, that's something that should be etched in your brain. That is something, as archaic as it is almost always tested. Mailbox rule. The mailbox rule basically says, look, when is an offer effective? An offer is effective when the party receives it. When is a revocation effective? And a revocation is effective when the other side receives it. But the mailbox rule puts a twist on it and says, no. The rules are different when it comes to an acceptance. If one party is accepting the other party's offer, it's effective when they send it, not when the other party receives it. Now, just by the name of this rule, the mailbox rule, you know it's sort of an archaic rule, right? It used at a time when things, in order to accept something, you were actually taking a letter, putting it in a mailbox, it was going out by snail mail, it was going to take 3 to 4 days, and in between something could have happened. Now, today, it's not that it's just, the mailbox rule only applies to mailed stuff, it applies to everything. It applies to when you send a text accepting something. So it has lesser meaning today, because today, when you send something, it's almost instantaneous to when it is received. But it could still mean something if you're talking about international parties or something like that, where, you know, an order is sent by a confirmation via UPS, and it does take a day or two. So the UCC still permits the mailbox rule and basically says that we will acknowledge that common law rule. Now, the thing here is that the parties are always free to change any of these rules. You don't like the mailbox rule? Say that it doesn't apply. Say that the acceptance is only valid upon receipt if you wanted to. But if you don't say it, the UCC will acknowledge the mailbox rule. The other thing about acceptance is that the UCC permits an acceptance of sales contract to contain additional terms and to still act as an acceptance. So again, if someone makes you an offer and says, I will sell you my goods for $2,000. Under conventional common law, basically the words out of your mouth should be, thank you, I accept. But something like, I accept, but gosh, I wish you would throw in 6 months of free service, right? Under common law, it's almost as if that is a counteroffer, right? You've said, I'll take it, but I'm going to raise the stakes, and I want 6 months of free service. Under the UCC, a lot of things that sound like a counteroffer do not act as a counteroffer. Again, the UCC really tries to make a contract be a contract and not have it fail. So depending on what it is, additional terms do not negate the original offer. That's not to say that the other party is forced to do what was essentially a counteroffer, but the fact is that it doesn't take the original offer off the table. Why do they do that? Because it is a way in which commercial transactions are going to be formed with less technicality, less artificial sort of rules. So depending on what the additional term is, it's not necessarily going to act as a counteroffer. One could accept, even though it seems like, well, gee, it seems like they want more. If. The if might kill it. But I will accept, but I really wish there was, 6 months of free service or something like that. Not likely to kill it. And again, words have meaning. Again, you have to look at the surrounding facts and circumstances. But what may sound under common law to be a counteroffer doesn't necessarily get treated as a counteroffer under the UCC. Okay? So again, these are just some examples of how the UCC is much more favorable, much more lenient, much more flexible in finding a sales contract where common law might not be as favorable. I might have left out one fact that I think is sort of I always call these things Jeopardy kind of questions. Remember we said, when we started talking about the Uniform Commercial Code, just to sort of step back a few minutes, we said, well, it's model code. Lots of states have adopted. It's a uniform kind of a rule, so it doesn't matter much between states. I mean, it's basically, the UCC doesn't vary, the commercial transaction between New Jersey and versus other states. But what's that one state in the United States that is a bit of a holdout, has a slightly different legal system, and has not adopted things like the UCC? Anyone? Louisiana, I'm hearing it. That's a Jeopardy question for those of you that, Why? Why Louisiana? Perfectly part of the union the last time I checked. Why is Louisiana a little bit different? Anyone? Yeah, exactly right. It still follows a little bit of that civil French kind of a system, even in their legal structure. And when we talk a lot about this in Business Law 1, the fact how our legal system is set up as with the federal government and the state governments sharing powers. So it's not like Louisiana is some sort of a maverick renegade or something, but within the confines of what they can or cannot do within state law, they don't follow the rest of the country as much. And this notion of having state statutes like the Uniform Commercial, the law in Louisiana can vary a little bit. So it's just something something interesting to keep in mind. And I don't know, maybe it's a fun fact that the CPA exam may or may not touch on. Who knows? But anyway, I forgot to mention that. Okay. Are we still talking acceptance? Yes. Accommodation shipment. The notion of I bought this, you gave me something slightly different, we have a breach of contract. That's sort of what we learned in common law when we covered contracts. But what about a seller that gave something a little bit different to the buyer as an accommodation, as a way of not breaching, but giving the buyer a different option, if you will? So an accommodation shipment is a shipment that is offered to the buyer as a substitution for the originally ordered goods when they are not available. How does the UCC look at that? Well, the UCC, again, in its desire to bend over backwards, treats the accommodation as a counteroffer. Yes, it is not what you wanted, and yes, it is a private agreement, and yes, you, the buyer, should have what it is that you contracted for, but could we interest you in something a little bit different? What would be the right thing to do here? Well, the buyer is either free to accept it or reject it, right? I mean, that makes sense. And oftentimes it's sort of what I'm talking about. I ordered 100 dresses for my department store. I wanted them, I'm just making up ridiculous examples, I wanted all, Valentine's Day is coming up, I wanted them all to be red, and slipping in a blue one and saying you're free to accept it or reject it is sort of an accommodation shipment, and I could turn around and say, no, I'm not paying for that blue dress, I won't sell it. Everyone wants red on February 14th. That's fine. Or I might just say, you know what? There might be someone who might like something a little bit different, right? You're putting the buyer in the driver's seat. It's an equitable sort of a remedy, and you're finding, again, a way to, quote unquote, fix the contract, have it still be functioning contract, then looking for technicalities to make it something different. Absolutely. So the question is there a time limit when it comes to accepting the shipment, did you say? Absolutely. And can I tell you what that time limit might be? A reasonable time limit. I mean, I'm not trying to be funny, but it's true. I mean, unless there is something in the contract that says you have 10 days to accept, and that's fine, because those terms will always trump what the UCC says. But if someone doesn't say something, that what is reasonable? It can't be 2 years later. It can't be 6 months later, I would even think, but within a reasonable time frame of what that industry would dictate is what my answer would be. All right. Nobody thought that this was going to be a review of Business Law 1. Nobody thought they were going to hear Statute of Frauds again. But here it is. It's the only time it makes its, no, I wouldn't say it's the only time, but we just can't get away from contract, the basic contract law. So yeah, everyone has learned about the Statute of Frauds, right? The Statute of Frauds basically says, yes, there's a general rule. General rule is that a contract does not have to be in writing in order for it to be enforceable, right? And I always sort of add to that by saying it's always a good idea to put it in writing as good business practice, but you're right, technically speaking, a contract does not have to be in writing in order to be enforceable. However, as I always say, in the law, you have the general rule, you have the exception to the general rule, and then oftentimes you have an exception to the exception. That's just how it is. But anyway, so that's a general rule. However, the Statute of Frauds is an exception to that general rule that basically says, wait a minute, certain contracts do have to be in writing, and the way we talk about those contracts is we say those types of contracts are subject to the Statute of Frauds. And they are, a defined subset. And we've learned about some of those already, things like, unrelated to the sale of goods, things like a contract for the sale of real property, right? You could, if you wanted to, two willing parties could perform on a contract that is completely an oral contract, but in order to enforce it, in order for a court to enforce it, they need to see something in writing. Right? And in the case of real estate, they need to see a lot of formality under state law, right? So another example of a contract that needs to be in writing are sale of goods over $500 and lease of goods over $1,000. Those numbers are sort of a moving target. Why? Because those numbers are low, right? They're quite low. Here we are in 2015. God, can you believe it? 2015. Yeah, those numbers are rather low. Well, remember what the UCC is. It is a uniform law that, that changes over time. A new revision comes out. States, if you've ever dealt with state governments or even federal governments, they move slowly in adopting new versions of things, right? New revised versions. So some states have continued to keep 500 for sale of goods, 1,000. Others have gone up to 5,000, right? So here's where state law could vary. Yeah, these sets of rules apply in the same way, but the question is, when does the statute of frauds apply? When is it that a seller that sells something to a buyer have to put that sales contract in writing, because otherwise it's not a contract that a court would enforce because it was subject to the statute of frauds. There you have to look to see what is the threshold. Yeah, the old law still is, under the prior version of the UCC, sale of goods over 500, lease of goods over 1,000, but these numbers are increasing, and as high as $5,000 for the sale of goods, you have to look to see what that particular state has adopted. But whatever the number is, yeah. And what does writing mean? Do you have to hire a lawyer? Do you have to write a fancy 5-page document every time you want to go buy something? Better not be the case, right? No. I mean, a writing can be a sales receipt. A writing can be an email correspondence, right? A writing, and again, the reason for the statute of frauds is simply because for certain transactions, good public policy is to make sure that, where there could be disputes, that we make certain contract be subject to writing, because it would make the legal system run more efficiently, and there would be not be this he said, she said nonsense after the fact. That's really the purpose of it, right? And that's why we set a threshold of dollar limit, because, under that dollar limit, maybe not as important, but above it, we are going to require parties. That's not to say that if you and I have a contract and we're selling goods, I'm selling you goods for $50,000, and we just have a handshake and a very oral contract, that there's something wrong with it. We're both on the up and up. I deliver the goods, you pay me, big deal. We haven't done anything illegal. We just had a contract that was subject to the statute of frauds, and we decided not to. Now, would I say as a lawyer that's good business practice? No, that's horrible business practice. But it was done, and there's nothing wrong with it. The problem is, what happens if we do have an oral contract, and we didn't put it in writing, and now you don't want to perform on it? Where is my legal ground to take you to court, right? So that's the issue. Will courts even entertain a contract that should have been subject to the statute of frauds? And that's why I say, whether or not subject to the statute of frauds, don't take, as a good business practice, put it in some form of a writing. Get agreement. Because, for one thing, the terms of the contract are what people are often arguing about. Well, yeah, I mean, I wasn't going to make payment on the 1st of every month. It was always understood that it was going to be on the 15th of the month, right? I mean, those kinds of things, are what makes the importance of having these terms set out in writing so very important. Okay, so let me just gloat on this, because statute of frauds to me is the perfect example of general rule, exception, exception to the exception. So here we go. What is the general rule? Contract does not have to be in writing in order to be enforceable. Exception, except for the fact that when it's subject to the statute of frauds. Let me add the exception to that rule. Oh, but forget about the statute of frauds if we're talking about specially manufactured goods, for example. And here, what do I mean? I mean custom-made goods. So what if we had a contract, oral contract, should have been subject to the statute of frauds, it's for $50,000, but we didn't do it. However, the subject matter of the contract is very, very customized product, a software that you can't go out and sell to the general public. It is very customized to my business. It's worthless to anyone else. And now that the other side has created this software, I say, I don't want it. I don't want it. I changed my mind. And by the way, I have my lawyers, and they tell me this contract should have been in writing, so I don't have to perform. Right? So here's the way that the law gets around that inequitable result. And by the way, this is not UCC, this is common law rule as well, which basically says that, hey, wait a minute. Can't hide behind statute of frauds when you're talking about custom-made goods. Okay, and there are other things such as, what if you agreed that you had a contract in the first place? You admitted to it in a deposition. Well, if you did that, then don't deny its existence, right? Part acceptance, you took a part of it, you accepted it, too late. You can't not, go forward on that part. You may be able to renege on what's remaining. So yeah, there are some common sense exceptions. And this is really review, really. It's all exactly the same as it was in Business Law 1 when it comes to statute of frauds. The only thing that's different here is that we're reminding you that goods over a certain price, when we're talking about sale and leases, are subject to the statute of frauds. Here's one of those rules that I think is important. It's a UCC rule, probably is fair game for the CPA exam. It's a rule that years after I took business law in college, I still remember it. It's called the written confirmation rule. The written confirmation rule. And here's how it works. Two parties to either a sales contract or a lease contract have an oral contract, meaning it's not in writing. They're talking face to face. I don't even know if that happens in the real world anymore, but let's assume real world. But now, look at what this says. Both parties are what? Merchants. Finally, we get to apply that rule with respect to merchants. Both parties are merchants, meaning they're not casual buyers or sellers. This is what they do, right? The seller is in the business of selling these goods. The buyer runs an enterprise that uses these goods, right? Okay, so stay with me. Two merchants have an oral agreement to, for example, buy and sell goods to one another. Now, statute of frauds applies, right? If you're talking about goods of a certain dollar value, statute of fraud applies. And here, statute of frauds would say, have a contract, right? A written contract. But what the written confirmation rule does, it gives a little flexibility to merchants and makes it easier to satisfy the statute of frauds and says, look, even though face-to-face, we just made a deal. I will sell you blank goods for $50,000 and we shake on it and we agree to it. And that's all we do, right? We don't do any writing whatsoever. I go back to my office, right? I am the seller, let's say. One of the parties writes a written confirmation within a reasonable time of contracting. I wake up in the middle of the night 3 days later and I say, oh, should have put that in writing, right? I traveled to LA to see you. I'm not going to see you again. What do? The next morning I sit up on my laptop and I say, Joe, it was nice meeting you. As we discussed on January whatever, we agreed that I will send you a shipment of X, Y, and Z on February 15th for a price of $50,000, and I hit send. Okay? That's all I do. By the way, writing doesn't have to be physical writing. Email is fine. And you might say, well, you didn't sign it. I don't have to sign it. My email is my authentication. It's signed. That's what the law is going to say. What do? You, Joe, well, let's call you Joe, do nothing. The other merchant does not give written notice of an objection to the contract within what? 10 days. That's what the written confirmation rules. It has met the statute of frauds. Okay? Now, if you get up and say, no, I don't want to do this, you send an email, whatever, that's fine. But if you just say, do nothing, that email fired off within a reasonable time of our reaching agreement constitutes compliance, if you will, with the statute of frauds. Yes? Proof is such a sticky thing. And I knew somebody would say, well, how do you know? Right? How do you know? Well, it may surprise, I should say it should surprise no one that electronic communications have a history. So, yes, if I can prove on my server that the email was properly addressed, that this company uses info at blank.com as their email address, that there is no record of this email bouncing back, because the other side might say, well, it went to my spam folder. I never got it, right? And the question is that legal defense? And I think that's an excellent question, and one that I would argue, again, reasonable courts, depending on facts, could come out differently, would say, look, you, Joe, are in the business, I'm picking on you, sorry, are in the business of running a company. Not setting your spam folder to a high enough level or not monitoring that is your problem. If the other side can prove that they legitimately sent an email that there is no reasonable basis to conclude is fraudulent, I would say that that's proof. So, and again, same thing, the mailbox rule, what if you didn't email? What if you sent a letter? And the other side says, I never got it. So what a lot of legal counsel tell people when you send a letter is, send it return receipt, or send it with proof, or something like that, that you can show that you sent it. I mean, is it unheard of to think that a mailman could drop a letter and never got there? It's possible, but it's highly unlikely. And proof of dispatch will probably protect the other side. And that's, remember, legal rules are not perfect, but you have to kind of find a way to balance competing interests. Okay, everyone will remember the written confirmation rule? Now do you see the value of why it's so important to read this stuff and reread this stuff? And, because these rules are, and I want to, I mean, in a way I feel like I'm apologizing for the UCC. It's a bunch of rules. It's a bunch of rules that we just have to kind of understand. Yes? Yeah. Yes, applies to merchants and non-merchants. So, yes, regardless of who the parties are. Yeah, so there are just a few rules that we cover that apply difference to merchants and non-merchants. If I don't highlight that, assume that they apply to either way. Yeah. Okay, where are we? All right, the last thing we're going to cover is, again, something that should sound totally familiar to just about everyone that has taken Business Law 1, and that is the parole evidence rule. Remember this one? It's like the close cousin to the Statute of Frauds because it's covered at the same time. Every time you teach Business Law 1 and you ask someone, what is the parole evidence rule? Someone always goes the criminal law route. Well, it has to do with parole. But I always say, look at how it's spelled. There's no E at the end. We're talking about parole evidence rule. It's a totally different thing. It has nothing to do with criminal law. It has to do with contract law. And here's what it says. And by the way, no different than common law as when it comes to the UCC. The parole evidence rule says when you have a contract, and here we're talking about a sales or lease contract, and you put it in writing, whether you had to or you were just smart enough to do it because it's good business practice. The parole evidence rule says that is intended to be the final expression of the parties' agreement. You wanted to write something into a contract that said this, we, a court looking at it later, or an arbitrator looking at it later, are going to take it at face value. Because if you wanted to say something different, you could have, right? You didn't. So the terms of the writing may not be contradicted by evidence of what? Some other agreement, whether oral or written, or the fact that, yes, we wrote this, but I have proof that we also said this at the same time, right? Because again, what does the law want? What does business want? Let me tell you. One of the things they want is certainty, right? It's, it's certainty. And, and the parole evidence rule just says, look, if you bother to put it in writing, for example, if you said that payment was due on the 1st of every month, and you didn't put any conditions on it, we're going to read to say payment is due on the 1st of the month. But now you have a party that says, well, 2 people witnessed me saying that, look, sometimes my payroll doesn't come in or whatever, and it'll be okay if I can pay it by the 5th of the month and I'm not going to, accrue interest. Well, if you wanted that to be your agreement, then you should have negotiated and put that in writing. We're not, after the fact, when the contract is clear, we're not going to read into it other terms that are not in that contract. That is the definition of the parole evidence rule. Yes? The filling gap rule is if you don't address it. That's a different issue. But if, and that's an excellent question because it's tying together the different concepts. So the question, if you didn't hear it, was like, all right, professor, you're telling me about the parole evidence rule, but didn't you just say there was a gap filling statute? Different concepts. What I'm talking about with parole evidence rule is it's clear what that term is, right? It's not as if you forgot about it. The gap filling statute is when you didn't address it. Yes? Yeah. Sure. Yes. Yes. Yeah, so the question is, we're talking about, here I'm talking about, let's say, a commercial lease. But what about landlord-tenant? What about I have an apartment, a walk-up that I'm renting and I didn't, remember, consumer protection. Remember, also, renting real estate is what? Not the sale of goods, right? So sometimes you have to step back and say, are we even talking Article 2 or 2A? When I say lease, I'm talking leases of goods. And leases of real property are not governed by the Uniform Commercial Code, number 1. And number 2, they're governed by real property law. And it could be a state has very different consumer protection laws and all of that other stuff. So we're talking about a whole different can of worms. But good question because it forces us to think about what is it that we're talking about. Okay, but when you, yes? Oh, you're saying, does the written confirmation rule negate? That's what our lease says. Is that what you're saying? Yes. Okay. Yeah. Correct. Correct. She's thinking like an astute business person, yeah. I get it. I get it. I get it. Okay. All right. So I'm with you, and I would say the short answer is I don't see why you couldn't do that. So I said the written confirmation rule is where you don't have anything in writing, and you're trying to put it in writing. So what you're saying is, can I take these two sets of rules and make them work together? Which is to say, yeah, I put a statute of fraud. I'm sorry, parole evidence, 4 corners. So that agreement. But we're both merchants, and I kind of woke up again in the middle of the night and said, gosh, I never got that in there. Can I, within a reasonable period of time, write to the other party and says, thank you so much for agreeing into the lease agreement. I'm memorializing in writing our agreement that if I pay within 5 days, no interest shall accrue. Thank you very much. I don't see why that wouldn't work if the other side doesn't protest. I think that's an excellent marrying of parole evidence with written confirmation. Yes? Yeah. Right. Yeah, but yeah, it's a good point. But look, you can always modify if both parties. So the notion is you could. Remember, what is a contract? A contract is an agreement, right? So it's final in the sense that the other party doesn't want to accept it. They don't have to accept a modification. To her point, the written confirmation rule is out there for merchants. I give you a reasonable notice. You have the ability to object. You don't. I would say that it passes my muster. Yeah. So when you were going with exception, I thought what you were going to say is, oh my God, is the parole evidence rule absolute? No, nothing in the law is absolute. There are exceptions to the parole evidence rule. For example, you were trying to give me gap filling, which I think is a different concept, but I think other things are exception. For example, what if the contract is not clear on its face? What if it might surprise you that there's ambiguity in this world, right? Two people can look at something, read something, and come to different interpretations. And guess what? They both might be reasonable. Now what do? Right? You have to go beyond the four corners of that document. And the court says yes. If the terms are not clear, reference can be made to certain outside sources because, again, the UCC is bending over backwards to uphold a contract. What are they going to look to? How are they going to decide a dispute if this goes to court or arbitration? And by the way, I use the word arbitration to remind you that not all legal disputes, in particular not all commercial disputes, will go into a courtroom. Most of these disputes are going to be decided under alternative dispute resolution, which means things like arbitration. Everyone know what arbitration is? Right? Well, an arbitration, there are different types. Arbitration is simply a different, someone other than a judge, an arbitrator, is going to decide a dispute, and it's going to not have the same formality as a court case would, but it could be binding just like a court decision might be. It could be appealable later, but it could be binding. So the reason I keep saying that is because that's how our legal system is evolving these days. But anyway, so what kinds of things are they going to look at? They're going to look at course of performance, meaning what? They're going to see, how have you, through the course of your business relationship with each other, seller-buyer, lessor-lessee, dealt with this kind of issue in the past, right? Your course of dealing. What does the industry do with something like this, right? So the UCC, again, comes back to this notion of we can decide this based on the information that may be reasonably available, such as the party's prior behavior or how industry deals with the lack of clarity or ambiguity in a particular situation. So if you learn nothing more about the UCC, understand that it is a flexible way of resolving dispute. Understand that the guiding principle is reasonableness based on, we're talking about commercial transactions, so we're not talking about things that are unique. We're talking about things that happen in industry, maybe between the same parties, and that is the way that they're looking to either decide disputes or uphold contracts. Okay? And I would say Chapter 18 was kind of our setting the stage and a little bit of a review in terms of terminology back from Business Law 1.